Good afternoon. My name is Rebecca Bandy, and I am the director of the Henry Latimer Center for Professionalism here at the Florida Bar. And we want to thank you for spending your lunch hour with us as we presented a fantastic CLE. I'm super excited about this topic. I do want to let everyone know that this webinar is being recorded and will be published on the Florida Bar's website, specifically on the center's CLE page and CLE feed. You are not being seen as part of the recording. However, if you would like to ask questions throughout, we do have the chat box open. So feel free to ask questions in the chat. In fact, Steve has asked me to make sure that you know he is open to questions. So without further ado, thank you. We are going to present how to impress partners and stay out of trouble with my friend Steve Lesser. Steve Lesser is with the Becker firm. He chairs the firm's National Construction Law and Litigation Practice Group. He is board certified in construction law by the Florida Bar, a distinction held only by 5% of Florida Bar attorneys. He devotes his practice exclusively to construction law and litigation, including government construction claims and defenses and hotel condominium disputes. He is a fellow of the American College of Construction Lawyers, and in 2022, he was elected to the Board of Governors for a 3-year term. He has received a number of distinguished awards, from the Florida Bar and the American Bar Association relative to his work. He is past chair of the American Bar Association's Forum on Construction Law, a nationally prestigious organization devoted entirely to members of the construction industry. The Forum is the largest construction lawyer group in the world and is known for its scholarly publications and programs focusing on developments and trends in construction law. Mr. Lesser is past chair of the Florida Bar Association's Board of Legal Specialization and Education, which administers the bar's certification plan and provides oversight over all 27 certification committees that focus upon a specific practice area. In addition, I know him because he is a long-term member of the bar's standing committee on professionalism, which of course is housed here in the Center for Professionalism. And I have worked with him on several CLEs and love everything he does. And I'm very proud to know him and to consider him a friend and colleague. So without further ado, I'm going to turn it over to Steve.
Thank you very much, Rebecca, and welcome everybody. I want to start out and talk a little bit about some things about being a lawyer. In addition to having a license and having the privilege of practicing law in Florida, one thing is really certain. If all we had to do was practice law, I think life would be pretty easy and we wouldn't get into the dilemmas that we're in. But the fact remains that as a lawyer, not only are we a legal counselor and a legal advisor, but we also wear many hats. We are often a author. We are often a speaker. We are a marketer. We are an administrator. We are often even a bill collector. And in some instances, we also serve as somewhat of a psychiatrist with respect to all that we have to deal with. And so we're pulled in a lot of different directions. And so that leads us to our discussion this afternoon about how to impress the partners and stay out of trouble. I'm looking to provide you with maybe some practical advice about how to make yourself more productive, more efficient, and all the while to stay out of trouble. And I start off with this great quote, not from some great lawyer or from great judge, but rather Elvis Presley, who taught us, quote, when things go wrong, don't go with them. And so let's get into it. The first thing we have to understand is that in light of all that we do, mistakes are going to happen. This poor girl, I mean, people screw up. She didn't mean to do this. It just happens. There's often a lack of attention to detail. For example, I wonder how many times or how many people actually looked at this sign before it was actually erected. So being in mind and keeping this in your mind about how to pay more attention to detail, about how things are going to get screwed up, how you may make mistakes along the way. What I really want to focus on this morning are a number of different ideas about things that you should keep in your mind when you are confronted with a dilemma and you have some difficult choices to make. The first thing I want to cite to, and this is going to run throughout this presentation, is what I call the first stupid idiot rule. This is a rule that says if you've got a problem, don't do anything, do nothing. That two, it will go away. And three, no one will ever find out about it. I can't tell you how wrong following this rule would be, because the reality is that if you let something go on and you do nothing about it and you ignore it, it will not go away. People will find out, and the repercussions of what you've done or not do will come to the foreground. It'll be much worse because you've taken away any obligation or any concept of trying to mitigate or lessen the blow from a dilemma that you have faced. So remember the first stupid idiot rule, because we're going to talk about that too as we get through this presentation. The next mantra I want to take you with is called money will make you stupid. And what I mean by this is that oftentimes you're a young lawyer and a client will come to see you, referred to you by somebody else, and the client will sit there and he will offer you a $25,000 retainer check and tell you that he wants you to be his lawyer. And while you're sitting there looking at this check, you are getting intoxicated by the concept of money because you're going to show your partners about how much money you brought in. You brought in a new case. Oh, it's going to generate so much income from the law firm. You're going to make a lot of money at the end of the year. This is your origination and everything else. And you're not focusing on the things that really, really matter. Because the client then tells you that you're the second lawyer that he's hired, that he wants you to handle his case differently. He wants you to be super aggressive. He doesn't want you to give any extensions of time. In fact, do not come to me and request an extension of time. I don't want you to give any extensions to the other lawyer. I want you to fight everything out in court. And then you suddenly become to realize that maybe the money is not worth it. Because what this client is asking you to do is to sacrifice your professional duty, your responsibility. Remember, you're the one with the license. You're the one with the privilege to practice law. The client has no license. The client has no privilege. The only thing the client has is money, and he's trying to buy you. And when that happens, you have to do what most people would do, is that the best move in the case is don't ever accept it. So when you see something like this occurring, keep in mind the fact that you'll be living with this client for a long time, and maybe the best move in the case is not to accept it to begin with. So here's a real world exercise and example. Many years ago, I got a call from a developer who was developing a lot of projects down in the Miami-Dade area, and he wanted to consider hiring me and my firm to handle his matters. And it was a very large engagement, very important engagement. And so I'm sitting there with the client, and he's telling me kind of like the things that we just shared about money will make you stupid. I really want you to be aggressive. I want you to be attentive to my matter. I want you to put me at the top of your list. I expect great service. And in the context of that, he asked me, in a legitimate question, he says, "Can I meet, another member of your team that's going to be working on this case?" And I said, "Sure." So I bring over Marvin. Marvin had worked with me for several years. He was board certified in construction. Really, really super nice guy, ultra professional, very diligent, and very knowledgeable about the law. And so I introduced Marvin to this client, and the client looks at him and he asks him this question. He says, "Marvin, are you smart?" And poor Marvin is sitting there. He doesn't know what to say. So, of course, he says that, "Yeah, I believe I'm smart." And then the client looks at him. He says, "Well, Marvin, if you're smart, are you smarter than Steve?" And it just dawned on me, what kind of a person would ask these questions of somebody in a professional relationship that they're thinking about hiring? He's just teasing you. He's just having fun. He's just entertaining himself. And at that point in time, my gut told me this is a client that you don't want to represent. And we actually turned down the engagement, believe it or not, because the best move in a case is not to accept it if you think it's going to go sideways. And it usually does. And so keep that in mind when you're being confronted with a situation where the client is waving some money in front of you. Great engagement. But if you're asked to violate or sacrifice your professional obligations, it is simply not worth it. Another situation I want to tell you about, it goes with the first stupid idiot rule, is don't hide the problem. And this illustration of the boat will have some meaning to you in just a few moments. But I want to tell you about a situation that I actually participated in. I've been the risk management officer of my law firm for a long time. And so anyone that has a problem with a grievance or a malpractice claim usually picks up the phone and calls me first. And so on one day, I'm sitting in my office, and a lawyer in a remote office called me, a real estate lawyer, and he said, "Steve, I think we have a little problem." And I said, "Well, what's the problem?" He goes, well, I think we're going to get sued for malpractice. I said, okay, what's the malpractice? What does it arise from? He goes, well, it arises from a closing that went south and it didn't work out well. I said, okay, when did you first find out that the client was not happy? He goes, about a year ago. And I'm saying to myself, a year ago, and you're just telling me this now? So what happened? He goes, well, it happened a year ago. I thought it would go away, so I didn't want to mention it to the firm. And so I'm thinking about this as I'm speaking to him, and I'm saying to myself, if this has been going on a year, this client must owe us a lot of money that hasn't paid. So I said to him, I said, how much money does the client owe us? And he said, well, the client doesn't owe us any money. And I was like, confounded. I said, how is that possible? He goes, well, every month when the bills came in, I took my check and I wrote him a personal check for the fees, and then he paid the firm. And I just can't believe that this is happening, or I'm listening to this, and I'm just dumbfounded by it. So I said to him, I said, okay, well, you've paid the fees. Why do we have a problem then? He goes, well, the client told me that after this last round, I was trying to appease him, that he was going to sue the law firm. And I said, well, what happened? He goes, well, I gave the client my boat. I go, you gave him what? He goes, I gave him my boat. Why would you do that? He goes, well, the client always liked my boat. We went out on it several times. And I told him that I would give him my boat as long as he refused to sue the law firm and resolve the case for malpractice. I just couldn't believe what I was hearing. The lawyer got fired just right after that. But the big part of this story is this, is that if you find out and you don't find out about a problem and somebody in your law firm or you know that there's an issue, if you go to report that to your malpractice carrier for insurance purposes, the carrier may deny coverage because they say that you didn't timely report the claim. And that's exactly what happened here. So if you don't alert somebody to the problem, if you hide the problem, if you follow the first stupid idiot rule, not only could you be potentially liable, you can expose your law firm to liability, and you can deny yourself the right to claim coverage under your insurance malpractice policy, which could be a disaster for everybody involved. So don't hide the problem. Let's talk about somebody that handled it well. And I want to tell you a little bit about this story, about the story of the Citicorp Center and William J. LeMessurier. There's an article that was written in the New Yorker magazine in 1995 called The 59-Story Crisis, written by a guy named Joe Morgenstern. And in the aftermath of this lecture, if you'd like a copy of it, I'd be glad to send it to you, and you'll let us know if you want a copy. But let's talk about the 59-story crisis. What's this about? Well, meet William J. LeMessurier. He was a renowned structural engineer at the time. He was 52 years old. He was inducted into the National Academy of Engineers because of his amazing structural design of what you see on the right side of this screen, which is the Citicorp Center, which is a 59-story building, at the time the seventh largest building in the world. And it was brilliantly designed by LeMessurier, who designed it on a napkin in a Greek restaurant, where he came up with this intricate bracing scheme about how to brace the interior of the building. And the easy thing about to understand about this building was this, is that the columns were not placed on the four corners of the building. As you can see here, the columns were placed in the middle of the building. And that was because he needed to solve a problem. And here was the problem. There was a church on the northwest side of the building that could not be moved. And so in order for Citicorp to build their headquarters in this location, they had to figure out a solution on how to deal with that church. So what LeMessurier did was he designed this whole bracing system so the columns would be in the center of the building, and it would cantilever right over the church, and it would be tucked under there. Now this building is currently at 53rd, between 53rd and 54th in Manhattan. And next time you go to New York City, go and look at it, because it is a marvel to see. Well, then what is the problem, and what are we here talking about then? Well, we're talking about LeMessurier and what happened to him and what dilemma he faced. Okay, so the Citicorp Tower is built, and LeMessurier designed it with an intricate bracing system, and he's also a professor of architecture. And one day he's sitting in his office in Cambridge, and he gets a call from a New Jersey architectural student nearby. And he says, Mr. LeMessurier, I'd like to speak to you about your design of the Citicorp Center, because the way that you put the columns in the center as opposed to the corners, my professor says that it's under design and you're going to have some problems. So LeMessurier, being the egomaniac that he is, he listened to the guy and he held himself back. But he said, quote, I was very nice to this young man, LeMessurier recalls. quote, but I said, listen, I want you to tell your teacher that he doesn't know what the hell he's talking about because he doesn't know the problem I had to be solved. And he promised to call him back later on. And the problem, as I mentioned, was LeMessurier had to account for this church that was tucked underneath on the northwest side of the building. And so LeMessurier later called the student back. He explained to him everything that he took into account. He gave him an article that was written about the greatness of this structural design. And LeMessurier says, quote, I gave him a lot of information. And I said, now you really have something on your professor because you can explain all this to him. So LeMessurier, you'd think that would end the situation, but it doesn't because LeMessurier feels, you know what, this student brought up a good idea. Maybe I should have my students study my creation, the Citicorp Center, and my design, and come up and talk about how great the design was and do an analysis of it and everything that went into it. So LeMessurier pulls out his drawings, he pulls out his shop drawings, he pulls out his calculations, and he starts reviewing the project. And as LeMessurier is reviewing the project, he becomes horrified. Why? Because he recalls a conversation he had several months earlier when they were talking about the design of a similar building, because LeMessurier designed the Citicorp Center to have welded braces at the joints. And what happened was to save money, it was decided that they would use bolts instead of welds. It was more expedient, it was less costly, and would probably give you the same result. Well, when LeMessurier started looking at the Citicorp Center and started considering the fact that the braces were bolted together and not welded, he believed that the building may have a structural deficiency. And in other words, it may fail in what they call a 16-year storm where there's quartering winds that hit the building. So LeMessurier called some of his colleagues, one in particular, went through the scenario with him, and he agreed with LeMessurier. And LeMessurier didn't stop there. He called an engineering firm that did a wind tunnel design up in Ontario, Canada, of the Citicorp Center, asked him to take into account the fact that these joints were not welded but were bolted together and what impact it would have, and they came to the same conclusion. LeMessurier is horrified because now what does he do? He's just received all these accolades. He's world-renowned structural engineer. His picture was on the cover of engineering magazines. What does he do? What does he do? So LeMessurier thinks the first thing he would do is he would stay silent. The chances of the building collapsing or having a structural deficiency is probably somewhat remote, but still people may die. LeMessurier says, I cannot consider that. That's off the table. He then considers, according to LeMessurier, committing suicide because his reputation would be down the tubes. Everything that he's worked for his whole life, his accolades, his recognition would be gone. But the fact of the matter is, people would still die. He couldn't live with himself. So what does LeMessurier do? LeMessurier does the thing that he had to do. He blew the whistle on himself. What does that mean? The first thing he did was he called his insurance company and told them that he designed the Citicorp Center. He thinks there's a problem. He thinks there's a structural deficiency. He thinks that the building is could be a disaster. What should he do? And they called him down, according to LeMessurier, to talk to him to find out if they thought that he was nutty or not, because this is quite a statement being made. So LeMessurier went there with a fellow engineer and they explained the situation to the insurance company. The insurance company just nodded their heads and said, okay, Mr. LeMessurier, what are you going to do now? And so LeMessurier had to make an appointment with Walter Wriston, who was the head of Citicorp. And remember, this is a fully occupied building at this time, and Citicorp was very proud of it. And Rince's office was in an upper floor of the Citicorp Center. So LeMessurier decided that he was going to call up Walter Wriston and arrange to see him and make an appointment to see him, which he did. Now, LeMessurier just didn't knock on the door and say, Mr. Wriston, I'm sorry, I created a problem. Your building may collapse. It may have a structural deficiency. We may have to evacuate it. I'm sorry that it happened and it's my fault. I have nothing else to say. He didn't do that. He said, Mr. Wriston, we have a problem. I caused the problem, but I can fix the problem. And this is what I propose we do. I propose that we go in there in the middle of the night, every night for several weeks or months, as long as it takes, and have welders weld together those joints that are bolted together. I suggest that we put sensors on the building so if there's a high storm in the area, we can have an evacuation plan. We'll call the Red Cross. We'll have an evacuation plan in case something happens to that building. And hopefully over the next several months, the building will be fixed and everything will be fine. Wriston listened to him intently, then looked at him and said, I'll prepare the press release, get to work. So what LeMessurier did then was he mobilized a whole force of people to come in there. He talked to the Red Cross. They got an evacuation plan together. They put sensors on the building and they monitored the building for any sway in it, any storms coming that would produce some quarterly winds that would cause a collapse or a disaster. And after many, many months of doing this, the building was actually fixed. Now, what's the punchline? The damages to fix the building at that time was an enormous amount. It was $8 million, dollars, and LeMessurier had $2 million dollars of insurance. What do you think the result was? Were they going to pursue LeMessurier for the balance of the money? The result was no, they didn't. Because this is what Citicorp said. Quote, it wasn't a case of, quote, we caught you, you skunk. It started with a guy who stood up and said, I got a problem. I made the problem. Let's fix the problem. If you're going to kill a guy like LeMessurier, why should anybody ever talk? And I think that's the point of what I'm trying to tell all of you, going back to this first stupid idiot rule, is that if you don't do the right thing, if you don't bring up the problem, you're going to lose the opportunity to mitigate it, eliminate it, and maybe nothing bad happens. And here's what LeMessurier said. He said, quote, you have a social obligation, end quote. Quote, in return for getting a license and being regarded with respect, you're supposed to be self-sacrificing and look beyond the interests of yourself and your client to society as a whole. And the most wonderful part about my story is that when I did it, nothing bad happened. And so what have we learned from LeMessurier? Well, we learned that don't follow the stupid idiot rule. And we learned that how important it is to have a license and how people rely upon us as lawyers. We are giving advice and they're relying upon it. They're using it in their business and in their lives. And so we have to take our social obligations seriously. I suggest to you some of the takeaways from this come on the following slide. If you've got a problem, don't ignore it. Write out and answer the following. One, what is the problem? Two, what are the causes of the problem? Three, what are the best solutions? Four, what is the best solution? And five, speak to somebody. And when I say speak to somebody, speak to a colleague, speak to somebody in your law firm. If you don't have anybody in your law firm, you can always call the Florida Bar Ethics Line. You can use the Counsel to Counsel program, or go ahead and hire a lawyer and talk to them about your problem and how you can solve it, because there are always chances to mitigate the problem before it mushrooms into something else. And look what happened to LeMessurier. And look all the choices that he was confronted with in solving his dilemma, and he solved it. And like he said, nothing bad happened. Let's move off of this topic for a moment and talk about scary things that can happen at Dunkin' Donuts, also a real world example about how to avoid the attorney-client privilege. So a couple years ago, I was in a Dunkin' Donuts and I was sitting in a booth, and I saw a guy walk in with a coat and tie holding a file. I figured he was a lawyer, and he was looking around and he finally sees who is potentially his client, who he's meeting for the first time. And he sits in a booth very close to mine. And they start talking. And it becomes evident to me that this individual is a criminal law attorney and his client got himself into some trouble. And right in the middle of the store, right in the middle of the Dunkin' Donuts, he asked his client, he said, listen, tell me what you did with the credit cards once you stole those. Did you use them? How often did you use them? Where'd you use them? Where'd you buy anything? I need to know this. And I'm saying to myself, I wanted to scream at him. I just wanted to scream at him to tell him that, oh my God, you have just blown the attorney-client privilege. You've just violated so many rules of professional conduct and responsibility. And so my point to you is that when you're talking or you're sharing information of a privileged nature, be careful. Don't assume that no one is listening, because people are listening. And that's one way to violate and blow the attorney-client privilege. There are other ways that can happen too. I've seen it happen at judicial receptions where two lawyers start talking. One lawyer starts talking about a pending case to another lawyer, starts talking about all his strategy, but he doesn't realize the lawyer he's talking to is best friends with the lawyer that also has a case with him that he's talking about. That's another way that you can blow the privilege. Be mindful about what you're talking about at these receptions or at public outings or meetings, because you could be blowing the privilege. Sending client information over to an internet to a colleague. What do you think of this issue? Also a way to blow the privilege. replying to all without intending to do so, improper sending documents to the wrong client on your phone because you're trying to expedite something and you're not even near a computer to make sure that the documents are going to the right place. These are all ways to blow the privilege. There's also some things that you need to be aware of. Here's a Indiana case that I discovered a few years ago, which was a horrifying result. It was Stephen C. Litz in the Indiana Supreme Court back in 2010. In this case, the respondent asked his adult children to dispose of 12 to 14 banker's boxes that contained the files of clients and former clients. At his request, his children took the boxes to a site where they had recycling bins. But they found the bins full. They placed the boxes on the ground by the bins. They didn't inform the respondent they did not put the boxes inside the bins. The wind later blew off the tops off the boxes and scattered some of the contents of the client files into public view. And after being notified of what occurred, the respondents and his children retrieved the documents in the boxes. The Indiana Supreme Court found out about this. They sanctioned them. These rules about professional misconduct, revealing information relating to the representation of the client without their consent, also going ahead and revealing information of a former client contrary to what the rules would permit. The same rules would apply in Florida. That's Florida 4-1.6, confidentiality of information, Florida 4.19, 1.9, communicating information relating to the representation or former representation. If you have client documents at home or someplace else, be mindful about where you dispose and how you dispose of those files because you may be violating the privilege and meet the same fate as they've met down in 2010 in Indiana, but I think you would still meet the same fate in Florida if that occurred. There's too much electronic communication. Lawyers are lazy. You're waiving a trial by jury in a text message exchange between the lawyer and the client. These are communications that have to be done usually in person, where you can fully discuss the ramifications of what you're waiving. These are valuable rights, constitutional rights, and yet you're sending a client a text message saying, "Do you waive a right to a jury?" This has actually happened, by the way. So when you're talking about, like, for instance, conflict of interest, if you're waiving a conflict, usually you have to have a consultation with a lawyer. You even have to represent that in the conflict letter. Don't short shrift the obligations you have as a lawyer. These are your obligations. You can't pass them off to somebody else, and you can't and you should not dilute them by electronic exchange of information. Another thing I will tell you, and I tell most lawyers in my law firm, I think it's really a mistake to ever speak to the client until you're up to speed on the matter. If a client calls you and they say that client XYZ is calling you, let them take a message, let it go to voicemail, and then go ahead, look at the file, study it, understand what the status of the case is. If there are other lawyers that are working on the case, then you should consult with them too before you answer the client. Because if you speak to the client and you're not prepared, then your client's not going to think that you're on top of their case, and it will not bode well for you in the future. So I suggest that you do that. Two rules that I learned when I was at the Attorney General's office. If you don't know what to say nothing. And if you don't know what to do, do nothing. The point of it is that before you go ahead and start making representations or answering questions to a client or opposing clients or a judge, so to speak, you need to stop, think, wait, discuss what you're going to do, and then act. Because a lot of people have a knee-jerk reaction and they start talking and they don't know what they're talking about, or they're not really being accurate in what they're saying. You don't want to take the risk. What I'm saying is you need to slow things down a little bit. You need to consider what's at stake and answer intelligently. Lots of times we've heard a lot about artificial intelligence. Every other CLE I think out there is about artificial intelligence. It's many now court systems have certifications that must be certified by a lawyer, whether or not you've used AI in preparation of pleadings or filings with the court. I would tell you that artificial intelligence is a good way to maybe get some information about a topic you don't know anything about, just to familiarize yourself. I remember I got a call from a client one day. They wanted to know about vertical integrated drilling. I wasn't sure what that was, so I got into ChatGPT. I put it in there. I learned a lot about it, so I can decide whether or not this is some kind of a case that we can handle or whether it is something that we needed to pass on. But what I'm saying is it's a good clearinghouse to find out what's at stake and to understand what concepts are that you may not be familiar with when the call comes in. Um, Key client qualities that clients really appreciate. And these are the things that you really need to pay attention to. You need to pay attention to detail. If you don't go ahead and spell check something that you're sending to a client, that's a big mistake. If you don't check over your notes of what your client gave you in terms of information, you put misinformation in a document or in a communication, your client's not going to appreciate it. Your client really wants somebody that pays attention to detail, that has listened, that is considered. And remember, they're paying you for this. You need to be detail oriented in answering them. They also don't want a lawyer that is not going to be enthusiastic. I've seen this many times before. Unless the lawyer is enthusiastic about the case, the client's not going to believe that the lawyer has their best interest in mind in handling the case. The client really doesn't want a dud. He wants somebody that really believes in the case, that's enthusiastic about it. If you're not enthusiastic about a case, then maybe you shouldn't be the one that handles it. The client also wants somebody with experience. And if you're a young lawyer out there, I suggest that you gain your experience. I suggest that you maybe pick a topic to write on, write a paper on, get published, or speak on the topic once you've learned the trade. Or in Florida, after you've had 5 years of experience, I highly recommend that you consider getting board certified in a specialty area of law because specialization is a great way to establish your credentials, to differentiate yourself from other lawyers that are practicing in the field, and it gives you the kind of experience that a client can rely upon. Also, a lawyer should be honest, of course, at any time and show common sense. And in fact, clients really appreciate honesty. You saw it with LeMessurier. He stood up and took the heat. And sometimes you just have to be honest and tell the client if you've made a mistake, that you made a mistake. Hopefully, you'll have a solution to that. That's what we've learned. But clients expect you to be honest with them. And sometimes you just can't avoid a problem. Sometimes you just have to take the heat. And if you do that, I think you're going to be better off in the long run. Um, Lots of times lawyers get in this habit of overselling a case or telling a client what they really want to hear. And that's not something that you should be doing. You should tell them what you think that is what they're paying you to do. They're asking you to be their lawyer. They're asking you to be their advisor. So when the client says, how much is my case worth? If you answer them, tell them it's a $10 million case and ultimately you only recover $2 million, you're going to give them a great reason for refusing to pay you because they're going to say that you told them that the case was worth X and it only was Y. Lots of times you get in a pickle because the client will say, well, will we win? And lawyers are scared to tell them what the answer is. I recall that I was in a mediation 3 days before the court was going to hear 30 motions in a case that we were handling. And the client took me aside. He said, Steve, are we going to win? What are our chances? And I told him 50-50. And he started arguing with me. And I told him, I said, do you want me to lie about it or do you want me to tell you the truth? We have a 50-50 chance on these motions. But, we're going to do our best to win them, but those are what the odds are. And I can tell you that whenever a client asks for representation, you should always preface it by saying, in my experience, I think this, because that is an accurate representation based upon your experience about what you think the outcome is going to be. But I've seen often lawyers go ahead and a client wants to know what direction they should take in a case. And the client sends a letter or the lawyer sends a letter that gives all these options but never gives any recommendation whatsoever. I think clients are paying you for a recommendation. I think they're paying you for your judgment. They want to hear what you want to say or what you have to say about the problem. That gets to billing. All billing should be reviewed carefully at the end of every month. This is a great opportunity to show your value to your client because the reality is that the bill may be the only thing the client may ever read, and that happens to be the case. Um, don't forget you're an expense to the client and you have to justify your existence, and billing is one way to do it. Um, there was a lot of CLEs about attorney's fees and about recovering attorney's fees, what courts considered. One thing that courts frown on in enforcing attorney fee award is no block billing. if you have block billing and you stream on several descriptions of bills in one entry, it doesn't help the court decide whether or not you should be enforced in terms of attorney fee award. So don't block bill. Courts don't like it. Also, clients don't like it either. If you go ahead and bill, your billing records must be accurate and they must be contemporaneous. In other words, you should be billing time as the time is incurred to make sure it's accurate. And your billing entries need to be very descriptive and tell a story. If you put down trial preparation 4 hours, the court's going to really have a hard time figuring out what you actually did, especially if there are other timekeepers in your firm billing for the same thing. So if you have a review of documents and you put bill review documents provided by defendant 4 hours, that is not a great description, but considered how you may want to modify it to the following. Quote, review and analysis of documents provided by Joe defendant to defeat defendant's motion for summary judgment and formulate a strategy to succeed on her motion to strike Mary McKenna as an expert witness 4.0 hours. If you bill in that respect and you tell that story and you specify what you've been doing, you have a better chance of getting this enforced, getting it paid by the client, and two, enforcing it by a court. Um, at the outset of any case where you have an attorney fee prayer for relief, make sure that you follow these billing rules and be accurate and descriptive to make sure that right from the get-go you're complying with what the court's criteria will be in terms of giving you a fee award at the end of the case. It's all about the value, how much they've paid. If you've given them a budget, you need to explain why the budget is higher than it is, and you need to show that through your billing records. Time, why did it take so long? You should be prepared to answer those questions. The billing reports are key, and you have to be honest with yourself. In reviewing the billing reports at the end of every month, you have to ask yourself, what have I accomplished? If you can't answer that question with certainty, maybe you have to be cognizant that the client won't believe it either, and you may have to go ahead and write off some time or give the client an accommodation or just go ahead and just adjust the time yourself to be in line with what you've actually been asked to do and what you've accomplished. Um, there's nothing ever wrong in admitting an error or a mistake and writing off the time. In fact, it might be better off to compromise and write it off if the value has not been achieved in your own mind or in your own sense. It may be the best result. Sometimes you just have to take the heat, as we mentioned earlier. So there's nothing wrong in admitting a mistake, but your billing record should be a description of what you've done, how you've done it, and giving meaning and value to the work that you've done as a lawyer to the client. How to improve your productivity? All it takes is discipline. Here's something that I would suggest that all of you consider as young lawyers moving on with your career is that oftentimes you may overlook things, things get lost in the shuffle. So I would tell you that all you need is key to success is a great assistant, be a bit of a worrier about your deadlines and what you owe other people and what they owe you. You need a pen, a billing pad, and a computer and a phone, and then you're off to the races. Let me show you what my customary way of doing things is. Every week, I prepare a to-do list which outlines all the matters that I have on the left-hand side and the information and the follow-up information that I need, whether I need to do it, whether or not I'm waiting for information from the client, whether I have to send documents to an expert witness, whether the other side owes me some answers to interrogatories or what have you. And you go ahead and you create this to-do list and you just go right through it, sending out emails, copying the client so they know that you're actually engaged on their behalf for that client. And this is all billable, and you're always trying to move the case forward. And I guarantee you, by sending out these emails, you will get back a lot of billable work to do because you're following up on cases and things that need to be done. So I would suggest that you get organized, you create a to-do list, and go through that to-do list every week. I think that you'll reap some benefits from it. Also, realize that clients want to be able to understand and read what you're sending them. So you get an email like this with some very small print. As crazy as this sounds, I would blow it up because clients really can read this a lot easier. It doesn't take any more time to do it, but be mindful that clients want something easy to read and that's can understand it. To that point, work on your drafting skills. I had a case against a law firm at one point in time. I sent them a very lengthy letter, and they sent me back a short response. It said, "Dear Mr. Lesser, thank you for your correspondence. We think that you will not prevail at trial. These are the reasons why." And they went boom, 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 boom. It was about a one-page letter, and they said, "We look forward to hearing from you." And I looked at that and I said, there's a takeaway in all this. And the takeaway is to bullet point your concerns. Make your points in a bullet point fashion in a letter. It's a lot easier to draft. It takes less time. It's less complicated. It's more expedient. You get to the point. And in a world where people have fading attention spans, they can read a shorter version of this letter and it will just hit the high points and they would appreciate it. So bullet point your concerns. I think that's a good practice tip. Um, and finally, lots of times the greatest lessons that we can learn from people are not from other lawyers, but are from people in the business world or from people like the punk rocker Patti Smith, who's going to tell you a little about some lessons in life, and I hope that you enjoy it.
When I was really young, William Burroughs told me, and I was really struggling. We never had any money, and William, the advice that William gave me was build a good name. Keep your name clean. Don't make compromises. Don't worry about making a bunch of money or being successful. Be concerned with doing good work and make the right choices and protect your work. And if you build a good name, eventually, that name will be its own currency. And I remember when he told me that, and I said, yeah, but William, my name's Smith, isn't that? Just joking. But to be an artist, actually to be a human being in these times, it's all difficult. You have to go through life, hopefully, trying to stay healthy, being as happy as you can, and pursuing, doing what you want. If what you want is to have children, if what you want is to be a baker, if what you want is to live out in the woods or try to save the environment, or maybe what you want is to write scripts for detective shows. It doesn't really matter. What matters is to know what you want and pursue it and understand that it's going to be hard because life is really difficult. You're going to lose people you love. You're going to suffer heartbreak. Sometimes you'll be sick. Sometimes you'll have a really bad toothache. Sometimes you'll be hungry. But on the other end, you'll have the most beautiful experiences. Sometimes just the sky. Sometimes, a piece of work that you do that feels so wonderful, or you find somebody to love, or your children, or there's beautiful things in life. So when you're suffering, just, it's part of the package. You look at it, we're born and we also have to die. We know that. So it makes sense that we're going to be really happy and things are going to be really fucked up too. Just ride with it. It's like a roller coaster ride. It's never going to be perfect. It's going to have perfect moments and then rough spots, but it's all worth it. Believe me, I think it is.
I think that Patti Smith is right. We've heard a lot about today about, the first stupid idiot rule, about money will make you stupid, about dilemmas that you may face as a lawyer. But I think that the most important thing that she talked about was the keeping of your good name, that the only currency you really have is your honor and your professionalism, your respect that you get from the colleagues, dealing with people straight up, not playing games. And I think that's kind of like the message that I really wanted to give all of you today. And finally, as I mentioned before, sometimes the best advice we can get is from non-lawyers, especially advice from this man, Warren Buffett. And he said as follows: it takes 20 years to build a reputation and 5 minutes to ruin it. If you think about that, you'll do things differently. And so I thank you very much for participating in this webinar. I hope that you found it to be helpful. And I'll turn it over to Rebecca to see if she has any chats in the slide in the chat box.
Any questions, if you want to put them in the chat? I don't have any as of yet, but what I did do is provide some information for resources. Steve asked me to do that for him. And so in the chat, you will see that I put information about Florida Lawyers Assistance. This is a program that has been around forever. They are not part of the bar. The bar does provide some grant money and stuff for them, but they are based out of South Florida, but they operate statewide, and they are amazing at providing all kinds of support, but especially for substance abuse. And so if you are having any kind of issue, stress related, substance abuse issue related, life related, these are fantastic resources for you. They're very active on the X platform, so take a look at their website, take a look at their social media. The second resource that I put up for you is the Florida Bar's Health and Wellness webpage. This is fantastic. It's constantly updated and refreshed with information, resources, statistics, really good stuff on that page. So take a look at that as well. And then on that page, there's information in detail about the Florida Lawyers Helpline. This is a helpline that is available as part of your Florida Bar resources. So every member in good standing can use it. The number is 833-351-9355 or 833-351-WELL. It is a 24/7 hotline that is available. You can call about budgeting issues, stress issues, your parents are aging, you're going through a divorce, you're having fights with your partner, anything at all, you can call this helpline. They are not affiliated with the Florida Bar. They are completely separate. We just pay their bill. Once you talk to their very trained staff, if you need additional help, they will pair you with a professional in your area. So they're Atlanta based, but they will find you help in your area. And here's the fantastic part. The Florida Bar will pay for up to 5 free sessions with this professional. Used to be 3, it is now 5. So you're married to a lawyer, you're dating a lawyer, you guys need couples therapy. Guess what? Each of you are entitled to 5 free sessions with a professional per year. So technically speaking, you go through the next year, you still need help, the Florida Bar is still going to be there for you. This is a phenomenal, phenomenal resource that a lot of people are not aware of. So we try to get the good word out. It's free, it's confidential. We get no personal information. We just get the bill. So use it, use it, use it. I also put information about the Counsel to Counsel mentoring program. It will start back up in October, so keep an eye out for that. We are on our this next year will be our 3rd full year of hosting the mentoring and mentee program. Free CLE credit in abundance through that program. Great relationship building. It's so good. We're getting so many wonderful stories from those involved. And so I urge you to take a look at that. And I have a question in the chat for Steve. In addition to reputation, what is the best single piece of advice you would offer to young attorneys?
Well, I figured that David Ehrlich would ask a question like that. Thank you, David, for that question. I would tell you that there's no compromising your preparation as a lawyer. There's no easy way out. You've got to do the hard work. You've got to study your craft. You've got to be prepared. And I think that's the one important thing that a lot of lawyers maybe get lost on, young lawyers, is that they try to find shortcuts. But there's no shortcuts. You've got to do the work. And I got to tell you, one thing I love about the specialization areas is that once you become a board certified specialist, you really know the law. And so you're not insecure about it. You see the same people over and over and over again in your cases. And it's more civilized way to practice law, I think. But I think in answer to your question, David, not only is it reputation, which I think is really at the top of the list, but it's being prepared as a lawyer in order to service your clients. I also want to mention that if anybody wants the 59-story crisis article from the New Yorker, you could email Rebecca and we'll get that to you. I think it's fascinating reading and something that you may want to use moving ahead and consider when you're facing an ethical dilemma. And I see Rebecca's put her email in the chat.
So Russell says, I understand that reputation is so important. What practical steps can you take if your reputation has been damaged? Great question. What can you realistically do to rebuild a bad reputation?
Well, start anew. It's never too late. And I'd say that what's happened has happened. Fess up to it and move on and be the best lawyer that you can possibly be and reestablish your reputation. There's no easy fix on that. It's going to take a lot of time, but you got to come back and you can't get discouraged and you can't give up. Because as you know, there are ways to come back. And ultimately, the next case that you have, you'll reestablish yourself as a professional, and that will maybe dispel anything that happened previously. Rebecca, you have any advice there?
No, I was going to say the same thing. I think being honest and forthright is the best PR move, so to speak. So, admit that you're wrong, admit you've done things bad. And then that leads to my question for you. I think it's so important that when you're struggling and making bad decisions, that you find a mentor. Steve, who is your mentor and how important have mentors been in your career?
Well, I was fortunate, Rebecca, because I had a father who was a lawyer who I practiced with for a short period of time. He was a great mentor, but in I've been very much involved with the Florida Bar and the American Bar Association, and I met an individual who was about 20 years older than me when I met him. And he was a mentor to me in that he taught me the value of bar service, volunteering for the bar, which I think was a great thing for me because it got me out from behind my desk. I met a lot of interesting people. I heard a lot of horror stories about malpractice and grievances and things of that nature. Because the more people you meet, the more stories you hear. But he encouraged me to get involved with pro bono activity for the bar associations, and it really got me on the right track because the fact of the matter is that you've got to be true to yourself and you got to follow and be appreciative of the license and the privileges that you have as a lawyer and not sacrifice that for anyone. If you stay true to that, I think that you'll get on the right road.
So oftentimes, and also Russell followed up with absolutely, he still meets with his mentor monthly from the Florida Bar's Council to Council program. So it's good to know. Thank you, Russell, for sharing that. Russell was also part of the Florida Bar's Leadership Academy. We just picked our current class, but if you're interested in that, we will be taking applications beginning in December of this year. So keep a lookout for that as well. But just kind of building on that, oftentimes I know in my position, we feel like we're preaching to the choir. Steve, you're super involved with the bar. Russell, super involved with the bar. How do we deal with attorneys that we come in contact with, other legal professionals, law students that we deal with who aren't necessarily on the right track, aren't being professional, aren't being the most civil, and aren't the ones that are going to join the bar groups and aren't the ones that are going to seek mentors? How do you deal with those folks?
Well, I think you'd be honest with them. I think one of the problems that we have, I mean, my firm fully supports bar activities and getting involved, and they support that. But there are other firms that I know of, Rebecca, that they don't support that at all. And so they tell their lawyers that, look, if you want to participate in bar programs, then go ahead and take off vacation time. We're not paying for it. We're not endorsing it. I would say that maybe they need to find a place that's more in line with what their long-term goals are and their career goals. But I think that if, I think that people need to be taught, and people need to understand what the value is of bar service and the value that you get from participating in that bar service and how it makes you a better lawyer and a better person, in fact.
Okay, with that, we are coming up. Any other questions really quick? We've got about 4 minutes left. Thank you so much. So this is recorded, as I said before. It will be available in about a week on the Florida Bar's website. We've got great comments coming in, Steve, about the presentation. Share it, So once we publish it, it'll be available on the center's website, also the center's YouTube feed. Make sure you share it with any and everybody that could use this information. It's free professionalism CLE credit. So we need that CLE credit. It's incredible, and this is really good information. For those participating today, I want to give you the CLE number. It is 9857. 9857, so you can claim your credit. But thank you so much, Steve. It's so good to see you today.
Thank you very much, Rebecca. Thanks for your help, and thank you all for joining. Appreciate it.
Yes, thank you. Have a good day, everyone.